So for today's forum, we'll assume that you and your school division teams are aware of the LAFOIP basics. There's a couple of core questions, obviously, that come to mind when dealing with the privacy work in your own school divisions. What is privacy? More importantly, what do your staff understand about privacy? And as we get further into the slide deck, how does that relate to the technology that you use and your students use in the school divisions? So the definition of what is personal information under LAFOIP, I'm going to let Geraldine address that at a high level in terms of the context of that personal information and how it might relate into the work we do in our school divisions.
Basically, personal information is personal information about an identifiable individual that's recorded in any form. It's a very simple definition, but if you look at it, we're talking about various levels of personal information. And if we look at the Act, it talks first about things about who you actually are. What is the essence of your being? That would be things like your race, your creed, your religion, sexual orientation, nationality. Those are who and what an individual is about. The other piece of personal information is about what an individual does. That is personal information. And this is things like your education, your criminal or your employment history. So those things about what you as an individual do, that is also part of your personal information. Things like health is also part of personal information as well. And then we get into some very particular things that are listed as well: identification numbers, addresses, phone numbers, and also the Act specifies that the opinions or views of the individual, and they are your own personal information, but also the opinions and views of others about you are also your personal information. So you can see it's a very broad-ranging definition that covers basically most information that we ordinarily think about as being personal to ourselves. And once it is, there's some other specifics here, and we'll just go very quickly through this. Tax information, financial information, and sometimes it can be in places, not just where you'd normally see your personal information be also included with other people's personal information. So again, looking at the Act will give you all this sort of definitions of it. That's the very technical piece of looking at what personal information is. So when you think about it, when we deal with it in a school division, what isn't personal information? We deal with education, so basically anything about a student's education, that would fall within personal information. And if we're dealing with staff, you're looking there about their employment history, you're looking about their education history, all of that kind of information, again, is generally personal information. So
it would be fair to say that we have a treasure trove of personal information in a variety of forms in our school divisions, some of which, of course, we're using technology to either gather, help deliver, consume, etc. So there are some things we should be paying attention to.
In today's day and age, where if you look at a student, we're gathering medical information, we're information from social services, from justice, and because we have access to technology, the amounts that we can store, the length of time that we can keep it, and the accessibility to it, and perhaps even the vulnerability to it is all increasing at rapid rates. So it doesn't change, though, the ultimate responsibility. No matter how much we have, we still have to apply the principles of the LAFOIP Act to all of that information, and if we mess it up, we're responsible for it.
Excellent. So that's what we're hoping to accomplish during today's forum, is really clarify on behalf of the individuals how we need to pay better attention to the use of technology and IT in particular in our school divisions when it relates to personal information and more importantly, privacy overall.
Absolutely.
So the format that we are working through is we've queued up a variety of poll questions that we will present, and then we'll look for your feedback in terms of the answers.
Great.
So the first question. So this first one just dealt with which of the following are examples of personal information that would be pulled from a typical school division. And if we run that poll, we'll find a wide variety of responses from our individuals. But if you care to comment on some of the ones that you see on there and qualify whether they fit into that profile of personal information.
Well, if you remember the definition we just went through and the broadness of that definition and apply it to these things, I think we'll find everything up there is or could be personal information. A student essay, that's part of the student's education, how they did, and plus the contents of the essay itself could disclose personal information of the student. Certainly the student's name, the mark on the essay, that would absolutely be personal information. A staff photo, images are considered to be personal information of an individual. Facebook postings, what are you posting, what is there? So that question would be, it could be personal information or it could not be, depending on the content that we're dealing with. Email with student health, definitely health issues that's about a person, so that's personal information. A superintendent's teacher summary, absolutely, that's about their employment history. Staff performance appraisals, the same sort of thing. Anything relating to how you do your job would be considered personal information. Certain staff things such as salary or what your job is are not, because they're specifically identified in LAFOIP as not being personal information, but that's a very minimal sketchy thing. Anything else about employment and notes that are made of interviews with employees, all of that sort of thing would still be personal information.
And we'll probably, the one example out of there that I think might need a little bit of clarification as we get into some of the utilities or some of the IT environments that would manage it is the student essay, primarily in the assessment feedback portion. So if the student writes the essay, hands that into the teacher, maybe just comment a bit on what would be the scope of dissemination that the teacher could make use of with that essay.
Well, again, the essay is a product that the student produces for an educational purpose, and therefore I think is broad enough to in itself be caught within the definition of personal information. Now the teacher then adds something to that contains more personal information about the student. And if one were to collate that or to pull that together, the question's also raised about how much of that is the teacher's personal information. If they're making notes, for example, on it, commentaries, that could contain personal information of the teacher. There could even be comparatives or things like that saying, this is something we talked about, you could do, there could be a lot of things. So and then if you take the data that comes from the essay and say you post that on a data wall in a school division or in a classroom in some way, then you're now creating more information that comes from that particular piece of work by the students. So then you also have other questions, of course, about the care and control of that particular thing. Where can that be posted? Can the student go and post it? Well, if it contains personal information about somebody else, the student shouldn't be doing it. And while the student's in the school, we have the care and control of that student, so we have to also supervise that student. So we have to ensure that they're not inadvertently giving out their personal information to the world. So you can see one thing that seems very simple from a very start. A student essay could have some very complicated thinking about how you actually would approach that from a privacy perspective.
Great, thank you. So we're moving into our next question, which relates to the idea of where do we store information as professionals in a school division. From a teacher perspective, could be right up to the director or the superintendent. So we posed out the question, do you think your staff members are using personal cloud storage on utilities like DropBox or Evernote? And so we threw this out and we got generally feedback that was a more prevalent practice than we had previously thought. Lots of our teachers are believing they need access to their documents or their information, or even senior administrators, anytime, anywhere. So instead of waiting for their IT departments to put in place a solution that provides for that anywhere, anytime access, they've gone to personal choice and now are continuing to use those utilities in their day-to-day business. Maybe if you could comment on that personal cloud storage and its implications to privacy and protecting personal information.
Well, it's the kind of thing that can keep a supervisor awake at nights, or keep a lawyer in business for quite a few years if it all goes wrong, which it could. If it's when you're using personal things like this for your own work, that's one thing. If it's information that is non-identifiable, maybe justifiable. But if a staff member starts using utilities that are not approved by the school division, not controlled by the school division, they are then opening themselves up to potential issues. The issues that need to be looked at, and we can talk about those a bit more if we talk about contracts, but these kind of things, you have to understand clearly what the terms and conditions of the usage are, who has control and access to the data, how the data is actually disposed of. I mean, they're starting to talk about in the literature right now and in the courts about the right to privacy. So where is that fitting in sort of these sorts of things? There's also the care and control issue. Any personal information, if it's stored in these kind of utilities, are still the information and belong to and are owned by the school division. The school division owns any product created by an employee in the course of their employment. So if a request is made for information, the school division has the legal obligation to collect together all data. If it has it all on its system and knows where it is, that's one thing. But if individual staff are using various different places to store, and they don't know how long they're there or how they're being accessed or used, that poses practical issues for the school division, and it also poses some legal difficulties if the school division can't show that it is able to access and provide that information when a legitimate request is made to do so. So it's not to say, however, that these kind of things can never ever be used. As with anything, if you understand the contractual obligations, if it's been approved by the school division, if there's knowledge about what's being used, then there may be situations where these things can be worked through. But there's a process that needs to be looked at before it's the scary part for me as a lawyer advising school divisions is people doing this and not telling anybody, with multiple copies of student personal information in areas where we have no control, and in some cases perhaps even not access to it.
Excellent. So the next poll really related to some specific examples of documents, and maybe if I could get you to comment on one particular concern that we've heard as an example. So assuming that a teacher is distributing a level of assessment which might include some grades, and they're emailing it to individual students. If the email system's owned by the school division and that mark information is transferred directly to the student, are there any pieces there that might cause some concern?
When you're talking about the delivery of data, and if I can go back to the old days when you had a piece of paper and you wrote a big A on it and you gave it to the student. You could do that straight away. You knew the student got it. You didn't know what happened to the paper after the kid went home, but at least you knew that your job as the school division in delivering that personal information was direct, and you could confirm that it was received, and you could confirm that it didn't go to somebody else. So if we think about that, it's a similar thing to email. If you've got a confidence in your system that it is delivering it to the right person, that they're getting it, that no other person is getting it, and if you can show that you have the appropriate technical security in place, that you have the appropriate policies and procedures, that nobody's using wrong passwords, that things are encrypted properly, that you're checking to make sure you're doing audits to make sure the right person is receiving it, then yes, you can do that. Well, as you can see by my description, it's not just oh sure, it's okay to use email to deliver it. It's okay if you meet these kind of criteria, so that you can, the job of the school division when we're talking about personal information is to keep that information secure, make sure it's only used or accessed by those who have the right to use or access it. So whether it's talking about handing over a piece of paper, whether it's phoning to give information, whether it's using an email, whether it's using a registered letter, it's all about protecting the privacy of the information. If you're going to use technology to do that, you have to be able to assure the student that that privacy of theirs will be just as protected technologically as it would be with other items. Now, the good thing, the advantage of technology is a lot of times you can actually protect the privacy better than just pieces of paper. They don't get caught in the wind. Other kids don't, steal them from kids. So the privacy protections that you can put in technologically, may actually be much stronger than other methods, but you do have to consider that. It's not just a given.
So again, that use of a personal service, so a teacher electing, for instance, to use a non-division email platform to deliver that, and obviously if they were doing that with 25 students and sending out 25 sets of marks, each of those emails would be contained in a non-division location, which of course would raise all kinds of concerns.
Then you've got, again, then the kind of criteria we're talking about, making sure it's encrypted, making sure it's going to the right person. You are not following through on those things. Plus, again, I mean, the bottom line in anything we say today, if you're violating school policy or admin procedures, that in and of itself is an issue. But it also, those policies set a standard of care, and therefore if you're not following the policies, you're following below a standard of care, which is what a court will look at to determine if there's some liability. So if staff members start using, or a teacher starts using their own email account to start doing things, then they're taking on their shoulders that obligation, that liability. They're breaching probably school policy. So the world of hurt it opens up is absolutely not worth it. It's the kind of thing that we do have to be very, very careful of.
Excellent, thanks.
Some of the other things on the list there, just to sort of go through there, I think all of the things there would be done by school division. I've certainly been aware of them, and I think all of them cause some issues. And I think in terms of the technology of it, the letters to parents, we don't really write letters to parents, but when you mentioned email, that was one I thought that is one that I deal with a fair bit, where parents want to ask for everything about little Johnny, and all of a sudden staff members are having to hand over the emails that they wrote about little Johnny. And they don't always realize at the time that that's part of Johnny's records. It's not just the cumulative file. So there's a whole, we tend to build up a lot of stuff. You can go back and forth with fellow staff members about an individual student on a lot of emails over the course of the student's life in a school that adds up.
So I know, again, we're trending into some of the conversations. Shadow IT comes to mind about personal cloud storage, etc. And some of our audience obviously are working in IT departments who have to subscribe to auditor requirements. They're far more aware of different legislative pieces, but ultimately, their ability to deal with data security kind of comes to our next slide, which I'm going to get you to comment on, which IT is always seen as controlling. IT looks at this. And then you've got on this other side the users who really they just want convenience. Mm-hmm. And it does kind of set up for this situation in school divisions. And again, it's getting more complicated even once learning is starting to embrace a broader subset of the use of the internet and disclosing information and building it into assessment routines, etc. So, maybe if you could just a little bit of a quick touch on about the danger of convenience. Convenience trumping control, and control, of course, trumping convenience, which is really the challenge.
Well, in my job, I like to have the control rather than the convenience ultimately, but recognizing the practicalities of this. But the control, and I say that because the law says we must do certain things, and that's where we start from. Some IT may have standards that are perhaps higher than what the law requires, but you cannot drop below what those requirements are, and they're set out in LAFOIP. You have to collect only certain things, you have to keep it secure, you have to use it properly, and you have to dispose of it properly. There are no options for that. So if IT departments are solid in that kind of work, that's really important. Now, having said that, there is still a lot of room for convenience, for doing things in a proper way, and basically it starts with the setup of the particular kind of use you want to make of technology. When you're doing that, think of these questions from the very beginning. Figure out how they can be done. Do that front work so that you're not just showing up the day before you want to install a particular app or have a kid use a particular program and say, now we want this, and then complain because it's not convenient. So I think you need to think of, and IT people need to be helpful in that. They need to educate, they need to work, they need to with people in the classroom, with teachers, with administrators. But the work can be done collaboratively, but it needs to be done up front. It's going to take IT a heck of a lot longer to correct a breach that happens. You're going to have not just IT involved, but you're going to have your superintendents up to your director, perhaps your board involved in a breach. You're going to be dealing with the media. You're going to be dealing with lawyers. So the convenience doesn't sound quite so convenient at that point in time.
So this particular slide probably would resonate with you on that conversation point about the laptop going missing and what did IT do preemptively versus now what is a division left to do reactively?
Well, and I mean, like here, Calgary Board is apologizing to parents. So, I mean, even to send out an apology letter to 2,000 students, and you look at the costing of just doing that without anything further, not just in the cost of the registered mail, but in the cost of the time and energy. But the cost to your reputation, it's just not worth it. So yeah, something like this, a stolen laptop, so as I say, keeps lawyers in business, but it could easily be worked at in terms of encryption, in terms of how you set up your systems, and how you set up your administrative processes and procedures as well. So yeah, good example. It happens in this province. It happens with laptops. It happens with memory keys. It happens with any kind of piece of technology, the mobile devices that we have right now, passwords. You just forget a phone and forgot to have your password on it, and all of a sudden, complete access.
Thank you.
I hope I'm retired by the time that happens.
So the next poll question related to again something that IT is typically asked to help provide, whether it's an electronic form, etc. But it's that view about from one of the fundamental principles of privacy is around the collection of information. And so the question is, does your division, when collecting personal information, always disclose its use? So wondering if you might just provide a little bit of some feedback onto that, especially when it relates to some of the uses that we're seeing with technology. So I know this particular question coming from the field is, so our teachers would like us to use Office 365, and we're now wondering, do we, when we're collecting that information, have to be upfront about when we might make use of it as a teacher for assessment, let's say?
The answer to this is, from a legalistic perspective, is always going to be yes. You need to disclose uses when you collect personal information. So now, how specific you have to be with each particular use, all depends on how you set up your initial consents. When we talk about disclosure of use, we're usually talking about doing it so that the people that are whose personal information is going to be affected, understand and know how that will be used. It's important to school divisions because the LAFOIP says when you collect information, you can use it for the purpose for which it was collected, or for purposes that are consistent with that original use. So what it does is set the parameters for how that personal information can be used. And that may change over time. So the more general you make it, but you still have to be informed. The person providing the information needs to understand the use, and they have to have an informed understanding. So they need to know how broad that will be. You need to be pretty upfront with it. So with technology, there may be particular pieces of information that are disclosed for particular types of programs. And if that falls within the general rubric of, well, we're using it for sharing on the internet in order to access programs that are used for learning, then that should be no problem. But think about that. Again, the forward thinking is what's really needed. When you introduce the technology, think about that. Is this already covered by documentation that we have? Do we need to do consultation? Is this something that we need to get specific consents for? Figure that all out and then go ahead and use the program. Get the consents or whatever is needed. Something that comes up in this is whether or not you have to have consent from parents before you use a particular piece of technology. And I think that's something that, in this particular kind of a situation, if it's something educational, the same way it would be for textbooks and stuff, you don't really have to get specific. So again, look at your overall media release forms, your acceptable use policies, and see what they disclose. And if they're sufficient, then you can go ahead and do that. But do it first. Do it up front.
Good. This next one I know is typically on the radar for individuals in school divisions in Saskatchewan. They look at what's happening in BC, potentially Alberta, other school districts in other parts of the country. But the question is there a requirement to get consent to store personal information, staff or student on US-based systems? So the view again about a division potentially subscribing to a site that collects applicant information for the school division would be an example relative to staff. But potentially for students, it might be a learning management system that an individual teacher or a district that might say, we're going to subscribe to that, and I want kids to store things like calendar, some of their assessment. There might even be some other information on there. Could you comment specifically on that view about US-based systems versus Canadian? Or is there kind of the same view that we would have to take for either?
Well, here in Saskatchewan, that's not the main worry. In some provinces, I think British Columbia is one of them, where there's actually there's actually laws about whether or not you can use U.S. storage. It's really a bit of a red herring. The key issue, and I mentioned this earlier about contracts, is what do the terms and conditions of the contract with the provider state? If you have secure storage, if you know that ownership is retained with the school division, and if you know that the material will eventually be completely disposed of when the service is no longer being utilized, then those are the kind of key things you're going to be looking for. And there are some really good checklists out there that will help you understand what kind of contractual terms need to be considered. But that's really where it's important, is what does the contract say? And if the contract is acceptable, then whether it's stored in Canada or the US really doesn't matter. In fact, there are some commentators who say that some of the Canadian laws that are available for various agencies to do searches are just as intrusive as any American ability to do that. So it's really more about knowing where you're putting the stuff.
Okay. And so from a division perspective that's looking to put in place a new utility on behalf of student learning, if they qualified it at a division level within contract for record management, record disposal, went through privacy impact assessment, it all checked off, at that point they wouldn't need the explicit consent of the parents to allow the students to use that utility.
No. And you mentioned privacy impact assessments, and those are, I think, things that we don't use very well in our province yet, but I really, really encourage school divisions to look at that. And they're basically just checklists of what to look for before you engage in a particular kind of program, or in this case you could apply it to a particular program or utility. There's some great checklists out there that you can check with our office or on our website, and it's called sassschoolsprivacy.com. Just put a plug in there for that, that there are some links to these kind of assessments that you can go through, and that's a very, very important help.
Thank you, and I'll put the plug in as well. That site has been hugely valuable to our school divisions in the last year for sure. Thank you. And then moving along, the next question really is about limiting access. I know from an IT perspective, it would go without saying that we really try to set up rules, policies, procedures in place, technologies that would limit the access. But maybe just a quick reference on that one. How important is it that divisions actually can, in an audit, say these data assets which contain personal information are guarded or protected this way?
Essential. I think this is where technology is going to serve as a very great help to school divisions, because the ability to track these things, to audit things, the ability to set up security, I think is something that technology is a great boon to school divisions. We've always had to do this, and now that we don't have to worry about who forgot the filing key cabinet, or the old thump 2 times on the side and you can open the drawer, we don't have to worry about that anymore. So the security issues are huge. Again, we mentioned earlier the breaches, laptops and things. If we can prevent those, and breaches are not just third parties coming in and hacking into our computers. Again, a lot of the literature shows that the breaches that you worry about are not from outside. The breaches that most often cause the most damage are those from your own employees and staff. So when we talk about sort of containing who gets to see what, this is a crucial component, and one where I think IT can be of invaluable service.
Maybe if you could comment just before we leave this one, from a legal perspective, the liability that comes into play if certain security procedures technically are not taken into account and put into place. And I'll use this from the risk perspective. So a good IT department will have evaluated risk. They'll have done some impact reviews. They'd have assessed their security model. And obviously, the more money you have, the more you can do. With limited budgets, what might you say to that liability piece for a school division that knows there might be vulnerabilities, but ultimately can't block all the holes or fill all the holes because of funding?
Well, and it's not just funding, it's also the rapid changes to technology, and then people always finding the new thing to do, and you have to correct it. So what we're looking at from the legalistic point of view is standard of care. That's what the courts care about, is what would it be a reasonable standard of care for the school division to take in order to protect its data. So what would a reasonable school division do? The courts will not expect you to have unlimited budgets. You'll have to work within a reasonable budget, but you can't also just ignore it and say, we'll take our chances. So it's got to be something reasonable. It will look at what other school boards are doing within the province, what other school boards are doing within the country. It will look at the types of information you're storing, where you're storing it, who has access. It will look at what policies you have in place. It will look at whether you try and enforce those policies. You can have gold-plated admin procedures, but if nobody's following them and nobody's checking on it, you're going to fall below the standard of care. So set reasonable policies, and that will be what the courts will ask you to do in terms of meeting your standard of care.
Which is great. That leads us right into the next poll, which really was that view of balancing out operationally. If you can lock it down, if you can protect it, make the expenditure, minimize the risk. But then appropriately, does your division have explicit policies and procedures in place related to that personal protection? So you see that as obviously the two go together really, really well, and divisions need to pay attention to that.
It's absolutely essential, and I think you can have there's some general policies and principles that you need to set out about privacy and the need to protect it, but you do have to dig down a little bit into the technological piece of it. I mean, even I've mentioned a couple times doing things up front. If your admin procedure requires somebody to go to a certain procedure before utilizing a particular program, that's what I'm talking about. Is it doesn't have to be a 30-page treatise. It has to be something explicit that says before you use something, check out the privacy aspects of it, and then implement whatever is reasonably appropriate to protect the privacy before you use it. Then, once you start using it, that's just great, and you do whatever audits are necessary from time to time. It will never be perfect. You are not expected to be perfect. You're expected, though, to take reasonable care, and it's the same care as a reasonable adult parent would take of their children. It's a fairly high standard, but it's not an impossible one to meet.
Would you say that it's evolving to the point where people are beginning to take more note about the privacy of the personal information they deal with at work because their own personal information is at such risk in this day and age?
Well, there's lots of surveys out there that certainly show that people have an increasing awareness of privacy issues, and you certainly see that in the media, and that's really good. The bad part, though, is that if you look at some surveys for younger students, they're the ones who don't understand, and they sometimes don't understand the implications, and they are the most vulnerable. So when I say that we have to take care of them, that's something that that we are held to a fairly high standard about.
Excellent. And this next slide was just illustrative of what we could find when people don't pay attention to either the procedures or policies, or even from the technical perspective. You know, this particular illustration of what could have gone south for a USB stick, had the IT department said basically, we locked it down. There is no way they could put that USB stick into that laptop and get that information off. So one is to be, again, the complete control perspective versus default to more, well, people should know better and we'll have a procedure, hence we don't lock it down, and someone wouldn't walk around with hundreds of EdPsych reports on a USB key.
Well, I'm old enough to remember when it became mandatory to wear seat belts, and I remember letters to the editor and people complaining and all sorts of things. Whereas nowadays, I think most people just do it automatically. Yes, it takes you the fraction of a second longer to do it, but you do it automatically. That would be great if we get to privacy, where we're just doing things automatically. One can say it's inconvenient to wear a seatbelt, but really, the balance of what we're talking about is not that a big a problem. So we can do that for privacy as well.
Good. This next poll question fit in with a comment you made earlier about protecting vulnerable individuals in our school division. So this question comes up quite frequently. Does your division need to get explicit parental permission for students who are under the age of 13 when they use non-division online services with students such as Prezi, Google, etc.? Specifically when most of those services, when you go to them, say you should be over the age of 13. So hoping that you could comment on that one, because I know it comes up quite often.
Well, I'll come from two perspectives. If you're using kinds of services or sites for educational reasons, then you should be ensuring that those are appropriate for students, that they fit the curriculum, they fit the educational objectives. If you're doing all that, it's the same as any other resource. Okay, the principles are the same, whether it's a book, a website, whatever, a photograph. So, number one, if it's all appropriate, if you're doing it for education, no problem. If you're starting to use things that normally students under 13 are not allowed to use, the question is, can they use it with parental permission? If that's the case, then you absolutely need parental permission before you use those sites. My question would be then, why are you using them? If for students under 13, if they're not supposed to be used for children under 13. So even with parental permission, our standard and things like Facebook and other things that require students under 13 that require you to be 13 or older to use them. There was a recent survey done that was almost a third of kids that are in grade 4 and 5 that were under 13 were using things like Facebook. So their parents are obviously letting them use that. But I mentioned the standard of care earlier. The standard of care we have is of a wise and prudent parent. So when we're talking about using services that are meant for only older students, we do have to meet that standard of care and be able to show that we are meeting that standard of care. So again, I look at what's the nature of the service, why are you using it. If it's something that it requires parental permission before a student can use it, then go get the parental permission. If it's something that you need for educational purposes that doesn't explicitly require parental consent, then you can go ahead and use it.
Yeah, this one would fit nicely under that view of blogging, where within the new digital fluency directives from the ministry, that's an appropriate forum for kids to begin to exercise, their reality in a digital realm. So would you say then you potentially could use that, but the caveat would be very well coached and managed directives to the students about disclosure of personal information on that service.
Yeah, and again, if the service itself, I mean, there's usually reasons why they have the age limitations. If you're addressing those age limitations, then through the education process, it's like, you know, the PG movies or things like that, where you have the appropriate guidance to do that. It's not a problem. The one thing that you don't want to do is, in most cases, like I say, you don't need parental permission, but if there is a parental permission on the service itself, that's when you need to get the parental permission, okay? Because you certainly don't want to be telling parents, we're gonna do that for you, and not letting parents know about it. Again, that's why I question, what do you do then with the student whose parent won't give permission? You still need to provide them with the educational experience. So if it's that important that you're doing it educationally, you need to have alternatives so that the same educational experience can be granted to that student. So picking what you use and why you use it, not that it's just a flavor of the month, but again, thinking about, you mentioned earlier that privacy impact assessments can help you ask a few questions about that and determine if this is really the right service, and if you're using it the right way.
Thanks. This next poll we moved into and looked to get from our constituent school divisions some feeling around where they felt their divisions are at around the amount of education, ongoing education to staff, in particular around the management and protection of personal information. Maybe if you just commented on what you've seen out in school divisions in Saskatchewan. I know that you've been doing a great amount of work with boards and divisions with leadership teams, etc. Maybe just give us your take on how much education you think might be taking place out there, and maybe more importantly, what flavor and form it might start to take on as we move forward.
I think it's increasing every year. I think as awareness is increasing, there's more and more questions. So we certainly see now a lot of divisions. I mean, very few of them have and I don't think there are any that have a full-time LAFOIP coordinator, but there are many that have assigned duties to individuals or to job descriptions that include LAFOIP coordinators who are starting to do some in-service within school divisions as well. We certainly, the website that we have, the sassschoolsprivacy.com, that's certainly being utilized more and more frequently, so hopefully some educational pieces are coming through in there, and we're certainly continuing to do some of that work. And the forum here is another example of where we have other agencies becoming involved in specific aspects. So I think that's all very encouraging. And I think it's encouraging not just from the educational perspective, but from the legal perspective as well, because when I talk about standard of care, one of the things that's really important is the school division taking reasonable steps to ensure that people are aware of the law and that they are following the law. So we have to follow LAFOIP. We don't have a choice. It exists. We must do it. You can't just ignore it because you will pay the piper if something does happen. So it is something that if boards do, it helps them meet their standard of care. In the event that something does go wrong, at least they'll be able to say that they've done some work. One of the first things that if you have a complaint to Privacy Commissioner's office is, what's your policy and what are you doing to educate your people? And if you can answer those with, hey, we're doing this, then you know you're halfway to resolving a complaint. If you're not doing it, you might as well, just say, well, you know what, sorry, we're not doing what we need to do.
So do you think it'd be worthwhile for a division? I know our school division offices are right next door to BHP Billiton, and when you go and visit their head offices, before they'll let you stay in their building, they actually force you to take about a 5-10 minute little quick study on emergency procedures within their building, and only when you can answer the 5 questions that go with it do you get to stay in the building. Do you see that evolving, in the public sector space, and maybe a comment if you've seen something comparable in other organizations where, they're qualifying their staff's ability to deal with day-to-day business in a privacy context to the point where they say, we need to know you're qualified?
We used to have, and probably still do in many divisions, a confidentiality policy. It used to be called. It used to be, usually about one page saying, I know I'm going to see confidential information of kids, and I agree that I'll keep it confidential, and I'm signing this document to show that I agree that I'll do that. That's pretty much been the limit of what I've seen in school divisions, and that at least raises your awareness a little bit. Some school divisions are talking about things like looking at least ensuring that all new staff members listen to a video, go to the website, have to spend at least, like at least look at things. We're producing some videos that hopefully will be able to be used by staff members. We're certainly encouraging that. I don't know that it's something that would be mandatory, but again, if you look at taking reasonable steps to ensure that you're meeting privacy requirements, doing that kind of overall education, ensuring that every staff member, including your bus drivers, including your caretakers, this is not stuff just for teachers or principals, this is stuff for every single staff member, at least understands the basic principles of privacy and the basic understanding that you got to keep this stuff confidential, and that if you have a question, then you better ask before you release information. So that's an interesting quiz that they have to pass. I endorse that heartily. But I think some minimal education, mandatory, I think that's a great way to go.
So our next one, you've touched on this a bit. Maybe we could just close it with a bit of summary context. The question we put out to school divisions was, do you use a privacy impact assessment when considering using cloud-based applications that contain student or staff personal information? Maybe just, again, tie that one back up and say, you talked about a checklist. Maybe just a couple of the key points that would actually be in that checklist. Like, what kinds of things would individual school divisions be looking at qualifying with a service provider? For example, SaskTel right now is heavily promoting co-location services for applications and data recovery centers, etc.
Well, if you think about the principles of privacy, that's a good way of sort of looking at it, or the life cycle of a document is another way of looking at it. It's sort of, a privacy impact is just a sort of assessment. So when you're collecting data, you have to make sure best from the source. So the question you'd ask is, where's the data being collected? What type of data is being collected? Are consents being gathered? So it's sort of looking at that initial thing. Then you look at the use of it, who has access to it, what are you doing to protect the access, what kind of security provisions are in place, disposal of it as well, how is it being disposed of, does the contractor have, in terms of the access, who has access to this, can the contractor override access, can we tell them when to delete stuff, will they delete it, is it permanently deleted? Those are the kind of things that you can go through. There's some checklists that are produced. There's a great one that the British Columbia Law Society has to deal with cloud computing. Again, we have the links on the website, so that are very, very specific to very, very particular things. We have some privacy assessments that are very, very general to help you go through to see, in terms of your privacy policy, do you have all these things covered? Another privacy impact assessment that we have is, you're starting up a new program. Here's some things to think about in that particular program. So there's a variety of pieces.
Like, I know some industries use ISO standards, so the finance industry, if that company's not qualified under ISO standards, you would just steer very clear of them. Potentially will we see that begin to evolve, and where school divisions should be paying attention to some level of certification in the providers that they engage with?
It's interesting, in the privacy world, there's starting to be certification of privacy practitioners. There's actually starting to be law schools that are starting to certify practitioners with main private practice in privacy. I haven't seen there. It's hard to come up with the standard things, but there's certainly work being done commercially. There's privacy impact assessments that you can do that. But I think the value of privacy impact assessments is also that you can create your own. That you, for example, if you're looking at teachers in the classroom wanting to, use particular types of websites that they have, you can develop one for your school division. Every teacher needs to go through this privacy impact assessment, and then they have to get it checked out. But you can set those up so people can pre-screen for themselves. So some of it is the variety that you can use.
Good. Thank you. This next particular question really relates to the view that things can go bad. How important do you think it is, relative to this question, does your division have a protocol in place to deal with a data breach with technology systems? How important is it to have that in place, and maybe comment on the scope of the team or the involvement from the school division if in fact there's a breach?
You absolutely need that. This is the kind of thing that when a breach happens, you have some legal responsibilities. You do not yet in Saskatchewan have to report it. That may be coming. But you really shouldn't immediately things like stop the breach, clearly. Figure out what happened and why it shouldn't happen again. You need to deal with the media. You'll need to involve your communications people. You'll need to communicate to those whose data may have been breached so that you can deal with that. So you're going to have to communicate with your people like principals, with people that deal with parents if student data is involved, or employees. You might be dealing with unions, so you're involving your HR folk as well. So think about that all beforehand. The last thing you want to do is running around once a breach occurs and ending up on the news and somebody interviewing you and finding out that the breach has occurred through that way. That's how your board finds out there's a breach occurred. That's the last thing you want.
Well, and I know some work has been done on behalf of the SSBA around educational continuity planning. I just participated recently in a forum at SASBO for the CFOs, and I used a lot of the materials that our school divisions provided back to the SSBA around educational continuity planning. And certainly, if they've developed out an appropriate continuity plan, this is simply one of those scenarios that comes out, but it's all about planning in advance. It's about knowing protocols. It's one of those things that major companies are facing now, and school divisions probably need to be prepared as well.
There's something in the news every week about major data leaks that are quite exciting, and if we mentioned the one in Calgary earlier that happened. It could happen here. It hasn't yet, but it could happen in the next 10 minutes. We'd have to deal with it.
Well, and I think maybe one of the things that school divisions have learned is you do need your internal team position, but if you at all feel uncomfortable, get some outside expertise when you have a breach, whether it's on the forensic side, whether it's on the legal side. That's why they pick up the phone and fast dial you. They should have you and their favorite security auditor available that could come in and help them with the forensics. But appreciate those comments.
A lot of it is about credibility to the public as well.
Yes.
And if something happens and you're right on it and you're telling the public, we are aware of this, we're dealing with it, this is what we're doing, you can stop a PR disaster in its tracks because you're already prepared and you're dealing with it.
Good. So this last question sort of really, it sort of brings us into why we're actually in school divisions. It's around trying to bring classroom technology appropriately into better positioning learning. So if you just comment about the idea that I want to be innovative, I want to be leading edge, and I want to use this classroom technology, but stop for a second, I'm supposed to be worrying about this thing called student personal privacy. Maybe if you could close just a bit, and even from our responses, like yes, no, maybe, or only in a closed learning system.
Well, I think the thing is that you said, should I be worried about? No, you should never worry about this. It should just be part of doing that examination of what you want to do innovatively. It just becomes part of the design of your educational program. It becomes one of the factors. You assess this from a variety. Is this good for the students? Should I adapt it for Saskatchewan learning? Where does it fit the curriculum? How does it work with privacy? What do I need to tell parents? Privacy just becomes one of those things that you work into. How do I decide what's the best thing for the kids that I want? It doesn't stop the innovation. It shouldn't be at all. It doesn't have to be closed. It doesn't have to be anything. It just has to be part of whatever it is. And that's, I think, the key thing we're trying to say here. And the thing that I think technology is a good partner in doing this. And if you look at that as a way that what we're talking about here is using technology innovatively in most situations, and privacy can just become a built-in part of that, which is a lot easier to do with technology than it would have been 10 years ago.
Well, it leads into our final slide, which was really about enabling school divisions to adequately deal with privacy and then address the IT constituent parts that really surface through it. And as you pointed out, having a team approach, people who are identified as leading that work in school divisions. Again, maybe just a bit of a final commentary on school divisions getting to that point where they're successfully managing privacy, and that IT is just one part of that overall conversation?
I mean, IT is the those are the people that are hopefully aware of the issues that are out there, and not just of that they exist, but how they can be resolved. That's what we're talking about, is resolutions to issues that might arise, or strategies, solutions, ways of doing it where you don't even have to think about privacy, where you can set, I mean, what I think is really interesting is in say, student data systems, where you can, right from the very beginning, set up who has access to it, how long the data is going to be kept, how it's going to be disposed of. So you can inherently build those in to those kind of systems. You can build them into the learning pieces that you're doing. And you can't do that without having that communication. We're all here for one reason, and that's to educate students, and privacy does not prevent us from doing that. It should, if anything, enhance that. And I think that's really what we're trying to do with some of the work we're doing at sassschoolsprivacy.com.
Well, and I know the IT conversation, at least provincially, is the profile's been raised because the auditors have taken note of practices, and that hasn't necessarily in all divisions translated through to where there's an ownership over the processes that are associated with that. But I think we're seeing the uptake, and certainly by ongoing efforts from the SSBA on the privacy front, the work that you're doing, people are beginning to say, oh, the IT people, they're not just kind of running around, this is all, why are they worried about that? That in fact that is all about privacy in general, and where they need to build out their processes.
We all need to think about this, and if we all work together, then we don't have to worry about it, we just do it.
Excellent. Once again, I really appreciate your offering of assistance to CETA as we work towards providing both this particular publication online, but also some very targeted resource materials that we're working on right now that would provide some of those quick checklists, some of those reference pieces that you've been talking about, so that school divisions actually can see where IT lives and breathes within privacy.
Yeah, I think we need to all work together on this. It'll all help.
Great. Thank you again.
Thanks.